Hello and a very warm welcome to the brand new edition of Policy Watch. I'm Kriti Mishra. Today we'll take a closer look at the Consumer Protection Bill 2019. The Lok Sabha has passed a new consumer protection bill which provides for strict monitoring and punishment for misleading advertisements. It aims to empower consumer courts at the state and district level to disburse greater financial compensation to the consumers. The bill also has a provision for setting up an executive agency called Central Consumer Protection Authority with a mandate to carry out investigations into violations of consumer rights, recall of unsafe goods and services, and discontinue unfair trade practices. The bill will replace the Consumer Protection Act of 1986. And to get deeper insights, I'm joined by Mrs. Pushpa Girimaji, consumer columnist, Mr. S.C. Aggarwal, senior member ASSOCHAM, and Mr. Suresh Mishra, professor, Center for Consumer Studies, Indian Institute of Public Administration. Welcome to Rajya Sabha Television, all of you. Girimaji, let me come to you first. This bill was lapsed due to dissolution of 16th Lok Sabha because it was pending in the Rajya Sabha. The government says that it is a milestone in protecting consumer rights. Take us through the journey of this bill.
I do agree that it's a milestone, particularly if you compare it with the 1986 law. In fact, the 1986 law, the Consumer Protection Act, at that time, it was certainly a landmark in consumer protection. What it did was it gave for the first time consumers their 6 rights, and it recognized the rights of consumers, and it gave consumers a parallel consumer justice system that actually provided for redress of their complaints. Now, that was fine. At that time, it was believed that this would really, the consumer courts, as they are, commonly known as, they would be able to discipline trade and industry and bring about a change in their attitude. And, in fact, it was believed at that time that the adjudicatory bodies would act as regulatory bodies too, and bring in the necessary changes in the environment. But unfortunately, that didn't happen. In fact, there are various reasons for it. One, of course, was the way the consumer courts function. It was believed at that time that the consumer courts would provide quick justice and quick, inexpensive justice, but that didn't happen. In fact, at that time, the Consumer Affairs Ministry said that you can fight cases before consumer courts without the help of lawyers. But unfortunately, the law itself was so flawed that it was an open invitation to lawyers. And with this came, complicated procedures and then delays in the decision or adjudicatory process and things like that. So today, what has happened is, in fact, for a long time I was arguing that one of the basic flaw as far as this Consumer Protection Act of 1986 is that there is no regulatory body to actually prevent violation of consumer rights. We only have, in fact, even though the Consumer Protection Act gives consumers 6 rights, there is a provision for enforcement of one right, that is the right to redress of complaints through the consumer courts. But there was no regulatory body to enforce the rights of the other rights, such as the right to safe goods and services and right to be protected against unfair trade practices and things like that. So as a result, consumers were not being protected, and then the consumer courts were ineffective in bringing about the change in trade and industry. So in fact, in 2000, in between 91, 93, 2002, the government introduced so many amendments to quicken the process of adjudication before these courts and things like that, but unfortunately that didn't work. So finally in 2014, when the government constituted a committee to look at what needs to be done, in fact I was also one of the members of that committee, Professor Mishra was also there. So it was argued that, in fact I very strongly argued that we need to have a regulatory commission, and the government was very receptive to that. And so that's how the whole idea of having a very strong regulatory authority to prevent violations of consumer rights and to protect consumer rights came to being. And then of course the government also came up with ideas of, say, mediation, introducing mediation as a kind of an alternate redress mechanism, since consumer courts were getting very slow. And then they also wanted to bring in some other changes, unfair terms in consumer contract. That's another problem that consumers are facing today, particularly in the housing sector. So a provision to deal with that. So, and then also product liability. So many of these issues were brought in so as to make this a very comprehensive law. So what one can say in a nutshell is that while the earlier law, at that time it was good, but it only looked at consumer protection in a narrow sense, whereas today this law, this bill looks at consumer protection in a holistic way, in a very comprehensive manner, and it's in line with the present day market scenario, and then the changes in the digital communication and various other things. So I think it's in tune with all these things that are happening.
So it's a very comprehensive bill to cater to the needs of consumers.
Yes.
Moving on, Professor Mishra, how will this bill address the vulnerabilities of consumers to new age trade practices like e-commerce and telemarketing?
Now, this bill essentially empowers the Department of Consumer Affairs to have regulations or rules which will guide the e-commerce and other sectors. Earlier, this was not there. Now, with the growing population, young population using e-commerce, it's growing. In that context, this bill becomes much more important because today there is no regulation of e-commerce. And we man the National Consumer Helpline, and every month we get at least 25,000 complaints relating to e-commerce. And so there is no regulation. Now, this bill is important because it tries to bring in some regulation to take care of the consumer grievances. Essentially, it will focus on implementation of consumer rights in the e-commerce sector also, in terms of, you say, the getting back their money, that is their standards of the product that are there, quality of product, refund policy. These are not there today. And in many of the e-commerce websites, you will see that even address is not there. So at least this will bring in some regulation into the e-commerce sector. That's why it becomes very important, because this is a sector which is growing and growing very fast.
Yes.
And the younger generation prefers to go on buy things from the e-commerce platforms. Now, e-commerce platforms, they say that we are just like a heart and we are not responsible. Even if you get a fake product, they say we are not responsible. It is the company which has sent that they are responsible. Now, it can't be that. The e-commerce platform have to be responsible of what is being shipped to a consumer. So, in that context, this act becomes very important, I would say.
So there would be regulation of the e-commerce sector.
Yes.
Let's get industry perspective from Mr. Aggarwal. Mr. Aggarwal, how can the government ensure effective implementation of this proposed legislation in line with global practices?
You see, in US, class suit can be there. So in this case, in this proposed bill also, class suit can be there, because as he said, in online dealing, e-commerce dealing, there can be many consumers who are hit by the standard format of the company, and there may be provision which is harsh. So in this bill, any unfair contract or any product liability can be come to the company. Like banker says to a housing person to a housing loan, if you pay early, suppose you have taken loan for 10 years, and if you want to pay after 2 years, they will say that much penalty will be imposed. If that is not reasonable, so in this bill that is covered, that reasonability has to be established, and consumer can go to the redressal court and can claim that this is harsh provision and it should be deleted. So any unusual contract, any terms which is mentioned in the contract can be corrected. So this bill is comprehensive bill, and through this bill decisions can be taken. The court has to settle within 90 days.
Yes.
Earlier there was no time limit. Average cases were being settled more than 1 year, and if any verification is to be needed by the court, still the time limit for 5 months. So this is better than the earlier one, the 1986. And I think in Rajya Sabha also this should be passed.
So it's a very progressive bill.
Yes,
But
progressive.
Girimaji, there's another important aspect of the bill, and that is of endorsements. Celebrities can no longer be callous in choice of their endorsements.
Right.
How do celebrities verify the authenticity of the product that they're endorsing?
You see, I must also say, before talking about this, I must say one thing.
Yes, ma'am.
That, earlier Monopolies and Restrictive Trade Practices Commission used to be the watchdog of unfair trade practices, including misleading advertisements as far as consumers were concerned. And they used to protect consumers. But once MRTP gave way to Competition Commission, and Competition Commission doesn't have the jurisdiction to tackle unfair trade practices. So ever since, we had a very big lacuna as far as protecting consumers against unfair trade practices were concerned, particularly including, of course, misleading advertisements. So to that extent, this, the authority, the regulatory authority that is envisaged in the bill, that, is will play a very powerful role there. And then coming to your question about, endorsers. Now, if you see the Advertising Standards Council of India, they have come up with guidelines for celebrity endorsements. So I think if one goes through that, it becomes quite clear. And also the law says that so long as you have shown due diligence in, before you endorse a product, so long as you have shown due diligence, then, you won't be hauled up. So I think there is that escape route for celebrities. And also I do feel that in, in these kind of, taking action against endorsers is important, because today what is happening is we know that several kinds of foods, for example, sugary drinks and many others are bad for consumers, particularly for children. And the government is really concerned about the way several non-communicable diseases are on the rise, like diabetes, hypertension and things like that. So the advertisements by celebrities, particularly sports persons,
yes,
actors, endorsing some of these unhealthy products can lead to a very adverse impact on the health of the country. So I think to that extent, it's very important that we bring in some kind of a regulatory process there to ensure that endorsers also become more careful. Today, you don't see that kind of, you don't see them exhibiting that kind of responsibility when they endorse a product. So this will make them think twice before endorsing an unhealthy food or, false claims and things like that. I think that should have a very major impact.
Ma'am, you also mentioned about the Central Consumer Protection Authority.
Yeah.
What would be the role of this authority?
Well, this authority actually, it has a chief commissioner and then commissioners, and they will look at various issues like basically enforcement of consumer rights. One of them is one of the most important. In fact, I feel under the bill, the authority doesn't focus as much attention on this, on consumer safety as it ought to. Because consumer safety or consumers' right to safe goods and services is one of the most important, the first rights of consumers in the present law too. And consumers have to be protected against unsafe goods. So which requires, kind of getting information on products which cause harm to consumers or which are potentially dangerous, which may even kill consumers. There are many such products in the market today, and right now we don't have any kind of a mechanism through which we can collect information and ask for withdrawal of such goods and give compensation to consumers and things like that. So the authority, one of the important role or the duty of the authority is to take care of this. And similarly, it will look at unfair trade practices. There are many unfair trade practices, not just misleading advertisements, and consumers are being exploited by the trade and industry, so they look at that. And similarly, unfair terms in consumer contracts. If you see all these housing contracts, in fact, only recently Supreme Court gave a judgment about how you cannot force a consumer when the terms are not when the terms are unequal. So we are having a lot of problems, consumers having a lot of problems with those kind of unfair terms in the housing industry, in the insurance industry, in various other industries. So this will also look at those, and hopefully they will examine such unfair terms and then put stop to them. But again, I do feel that in this particular bill, the definition of unfair contracts is very narrow. I do hope that even at this stage, they will make it more broad based so that it becomes far more powerful. And then similarly, they will look at consumer detriment, things that are causing consumers loss. Also, they will try and educate consumers. Today in India, consumer education, consumer awareness is really very, very poor. So, they are going to take up that issue. So, things like that, various, in short, they will actually enforce the rights of consumers and ensure that today there is no mechanism to stop such violations of consumer rights. So, they will stop them so that those do not happen.
Professor Mishra, Girimaji mentioned about consumer awareness. Now, the success of this legislation will actually depend on how vigilant and cognizant our consumers are. How will this bill ensure ease of approaching for the consumers?
No, now like in the redressal mechanism, you can file online complaint. I think that is one which is really going to help. Because the younger generation, if you ask them to go for a manual, they would not do. But sitting at home, they are prepared to file a complaint. So I think the first step is making justice system more accessible to the consumers. So once they file, there is a process which is much simpler than easier now what it was. And the second most important is the district forums can also have circuit benches. They can go down to the block level. So more people can have access to, otherwise one has to travel to the district and take time. That is, I think, two ways where the consumer is going to have access to the redressal mechanism that is there. And obviously, I agree with you that it's the awareness, education about the bill. Now, last Consumer Protection Act of 1986, we did a study around on 25th anniversary of the bill, and hardly 16% of the people were aware that there is a. So maybe now we have much more better systems, media and other things to reach the consumer, and education will be a big issue, because unless you educate the benefits of this legislation, I don't think much will be able to.
Talking about another aspect, Mr. Aggarwal, and that is of the provision of mediation cells. How will it simplify the process?
You see, they have mediation cell, every district, state, national level, they have mediation cell. But normally what happens, if a consumer file a complaint, manufacturer, supplier, they want to reconcile. 90% of the complaints, if they think we are wrong, and otherwise if we not settle it, court will impose penalties, and that will be more punishable. So that is happening. So mediation cell role is very, very important, and things will be settled without any dispute, and amicably settlement make both the party happy also. So, and CCPA, which is the regulatory authority, as you asked, the system is easy. Online complaint can be filed. Written complaint, you can send the complaint to the district cell commissions and national, whatever the limit is there. And even CCPA can file the complaint on behalf of the consumer. If they find certain things are going wrong in it, so then they can file the complaint to the district, state, whatever the jurisdiction is, they can file the complaint.
But won't that give rise to multiple litigations?
Yeah, it will happen, but I think things will be sorted out in time to come. If any multiple complaints will be there, as role of the president and their members is not defined. Who will government has to appoint? They are not judicial person even, so they don't know the judicial process. So things will be little bit complicated, and even the protection advisors like on all district, state and national level, there will be consumer protection commissions will be there, and under the in charge of ministers of state as well as food minister and central minister. So even those commissions are not very clear to whom they have to advise. So things are in place. I think things will be better in time to come.
And it's a progressive law.
Yeah,
but Girimaji, there's another important issue. We've had instances wherein different states had different reports on certain products for allegedly being unsafe. This sense was reverberated on the floor of Lok Sabha as well. What happens in such cases now?
You mean different states had different reports
Different
about
reports.
the same product?
Yes.
Yeah, we have to see that's because in many states we don't have state-of-the-art laboratories. So it's very essential that we need to have many number of laboratories, and they should be really up to the mark. So long as you don't have that kind of facility, then these kind of questions come up. So we really need to have laboratories, and they should be state of the art, and so that when they give a report, nobody should be able to question it. So that is absolutely essential. In fact, I feel that it might be good to even get the help of IITs and IIMs and others to provide their facilities for setting up laboratories so that they can be used. Having said that, I just would like to flag one issue here, and that is, my worry is still about the consumer courts, the time taken by consumer courts. You see, the thing is, the consumer courts, when they were, as I said, when they started functioning in 1986, they really opened the floodgates of consumer litigation in this country, and consumers were very happy. In fact, I remember I wrote about how thrilled I was about it and all that. But unfortunately, what happened was that the slow process of adjudication really disappointed all of us. And in 2002, the government brought in some amendments where they said cases should be decided within 90 days.
Yes.
But by then, the system was already set. All it had become like a civil litigation, and so all the trappings of the civil courts had already, these courts had imbibed the trappings of the civil court, and not much could be done. In fact, a study done by Indian Institute of Public Administration in 2013 showed that only 10% of the cases were decided within the 90 days. So one of the things is his study, IIPA study, and also CAG study, they all showed that lawyers are responsible for these delays because they keep asking for adjournments. I know of cases where 20, 25 adjournments have been given, even in cases where the complainants were 80-year-old, 82-year-old people. So, in fact, some of us were arguing that lawyers should be kept out of these courts. In fact, in 2002, when the government brought in some amendments, they had brought in that clause, but subsequently, while it was before Lok Sabha, that was removed because lawyers were threatening to go on strike and things like that. This time again, the government considered it, but unfortunately, it didn't happen because some consumer groups also were against it and things like that. But I do really feel that this, at least, restrict them to high value cases. In fact, Parliamentary Standing Committee had said that for cases up to 20 lakhs, keep lawyers away. I think that would help poor consumers who want to file, because today what happens is, if you get 2 lakhs as compensation after fighting for 14 years, 15 years,
Absolutely.
all that money would have gone towards paying the lawyer. So you really don't get much. So I do feel that this is something that the government really needs to consider. Even at that stage, just an introduction of a clause could make a difference.
Ma'am, I have last 30 seconds. So this bill would be a game changer?
Absolutely, absolutely. Like I said, I have certain reservations about a few things, but it's really a very comprehensive law, and I'm really glad the government has brought in this law.
All right, on that note, thank you so much for joining us. So consumers are the backbone of the economy, and no progress can occur without safeguarding their interests. That's all we had for you in this edition. Thanks for watching, and stay tuned to Rajya Sabha Television.